My lord, if I am permitted to mention one matter, this is a mandamus appeal matter pending since last year, my lord. This is a mandamus appeal matter.
Pick up, don't worry.
My lord, may I give the sleep?
Pass on the slip.
I'm great.
Bail matter and for correction. Now this matter was heard by the last circuit, last bench lordship. Now and the order was delivered to sitting in the principal bench. Only for correction. The correction is because it was satisfaction instead of the first court, it has been typed as second court.
Good. Can't be done here. Danger. Call.
Yes, Your Lordship.
Whose order? You want to correct?
The order was
Order
passed by.
taken. Order to your lordship 16.
Sorry. You have to move there.
Lordship, actually, so for the correction is concerned, PS
Sir.
police station case number.
Sir, we can't do it. We can't put a one line into an order of another judge.
Now, Lordship,
We'll have to mention it before the principal bench. No, they will.
now, Lordship, one problem
I
I have to say
appreciate, but
that the order is remain in force for 4 weeks, but I cannot.
whatever you'll have to do.
Lordship,
You mentioned the file would be immediately sent there.
Lordship.
Yes, call.
And for the petitioner, your lordship, actually, when the matter was called on, this is a restoration application. I was in
Have you
court number
served-
3,
Have you served the copy?
lordship.
There is a service.
Already after service, the matter has been filed. After service, the matter has been filed.
Who is for the other side?
I think Mr. Udbin Choudhury was other side in the main application.
Where is he? Why? The restoration application. Oh, we will not record his, where do I get it that you have served, sir?
Lordship, at the first page.
Yes. No, there is nothing.
So until and unless I have served the copy to the state, filing section did not accept our petition.
No, that is, I do not know why they are introducing this kind of a thing. There is no necessity of service unless the court directs the service.
সার্ভিস তো করছি আমরা। হ্যাঁ ঠিক আছে ওইটাই।
Yes,
Well, I am for this state.
thank you.
He got the copy.
Thank you. He said, I am for the state. I said, thank you. This is an application for restoration of the instantaneous application in which was dismissed for default on 7 July 2020. It is stated in the application that that the London advocate who was instructed to appear in the instant matter on behalf of the prisoner was in fact engaged in courtroom number 3 and could not attend when the matter was called on. A litigant not suffer because of the lapse of the latches of the London advocate. Furthermore, the court should encourage the disposal of the matter on merit rather than to nip into parts on the anvil of dismissal for default. The explanation offered in the instant application is satisfactory. And we are of the opinion that the petitioner was prevented by sufficient cause in not appearing on the date. The application was allowed. The application for bail is restored to its original file and number. Let the said application be listed tomorrow. Great. The plan one. With Deboshi Dhar. Who is appearing? Deboshi Dhar. And if they are not interested, then what can be done? Where is Mr. Deboshi Dhar? He was here, I am told.
Only it has not been included. The trial court, they are what in appellate
Yes.
court.
Leave is granted to the advocate and record of the applicant to impede the left of parties who were present before the court of appeal below, here and now. Impede. And how to be impleted, you know. You have to just impede number 2, and then at the bottom, you'll have to say that impleted with the leave of the court granted on date, and then put your signature. Call the next. We'll take up your matter, don't worry. First you will plead. How can,
Hi, my lord, I'm appealing for the
start.
appellant plaintiff.
the application for condonation is here,
Yes, yes.
has to be heard by a single bench.
Sure, sure.
The instant second appeal has been filed and beyond the statutory period provided therefore, along with an application for condonation of delay. Since the said application is required to be heard by the single bench before the matter is posted for admission under order 4111 of the court, let this matter go out of this. Liberty is granted to the appellant to pray for listing of the application for condonation or delay before the appropriate bench.
My lord, affidavit of service, my lord, there, lordship. My lord, there is a defect, my lord. Please don't be granted, my lord.
Why defect?
My lord, the name of the, my lord, the learned judge of the trial court has not been written in the preamble, lordship.
Has not been written. Do you know appellate side rules? What it says?
The names should be there, my
Oh.
lord. Of the
Why-
first
why-
appellate
why you
court.
peoples do not do
My
that.
lord, I have written the name of the learned judge of the first appellate court, but I missed the, my lord, name of the trial judge, name of the learned trial judge.
Very interesting, madam. You have obtained a certified copy of the operating portion of the order, but you have not taken a certified copy of the full text of the order. Is the appeal maintainable?
My lord,
Yes.
certified copy of,
Yes.
my lord,
You
even
have taken a certified copy
Copy
of
of
order
the-
number 5. I'm reading for you. Today, the case is fixed for passing judgment. The case is taken up for judgment. Both sides are present in court. The judgment is ready in separate sheet and is pronounced in open court. The operating portion of the judgment is as follows, hence ordered, whatever. Where is the separate sheet?
my lord, may I go
So
through
it's a
the?
defective.
Yes, your lordship, because in my petition, my lord, the order of the appellate court, order of the trial court, enter, my lord, the judgment and decree is there.
Okay. What you have done, you don't care that what is to be
My
done.
lord, I am sorry, my lord, but that should not. No, no, no. This is in respect of, I am in item number 5, my lord.
We have called 5 or 6.
5, your lordship passed the order for
So,
delay?
so now 6,
No, my lord.
Shubhasis Mishra,
No, no, this is not.
where is
mine.
he? 6. Where is he? Anybody knows him? Where is he? Call him. Seven.
My lord, please fix the matter on 8. My senior will be appearing.
Do it.
I have no instruction about it from my senior. Will be there.
You are there in, you are the advocate on record,
Yes, sir.
do it.
Please fix it on 8.
You do it, madam. Yes, what is the fact? Madam, tell us, you have drafted the memorandum, you have drafted the petition, you know the fact.
My lord, happened for 1 day, sir.
No, do it, do it, do it. Do it. Have you not read the brief? Tell us the fact.
Sir, he is not well, sir. Please fix it.
What?
1 day. So 1 day accommodation.
For what?
Senior is not well, sir.
Senior, you have to do it. You are the advocate on record. No adjournment on the ground of senior. Why did you tell us the fact? You have not read.
I am not aware of totally, sir.
You are not aware means.
I am not.
You are the advocate.
I
on
have
record.
done so, but my senior is. not
No,
well.
no, madam, they have to do it. The responsibility of the advocate on record that he has to do. Or she has to do.
No, I will be ready tomorrow, sir. Fix it tomorrow, please. Sir, tomorrow, please.
With an undertaking that you will do. That's an undertaking that you will do. Your senior will not ask. You will ask. Grant your time. Tomorrow.
With regard to item number 6, my lord.
Yes, what you have done.
My lord, the defect has not been cured, my lord.
Are you aware of the defect?
Lordship.
So
My lord, the operating portion of the, my lord, the
is
certificate.
is it sufficient? I'm just.
No, my
asking
lord.
you. Then
My lord,
why
my
you
lord-
will not give the full text of the order?
my lord, till date, my lord, I have not been, my lord, supplied by
Sorry.
my client, my lord.
You have,
Lord-
you got it,
My
that
lord-
certified copy and you have not got that certified copy.
My lord,
Are you aware that the limitation would intervene? Because if you have applied certified copy after the period of limitation, then the whole period has to be
lordship.
explained.
My lord,
Then,
by, my lord, Monday, my lord.
so we are dismissing it.
My lord, Monday, my lord. My lord, by this time, my lord, I will obtain, my lord, the certificate.
Not this week.
But item number 3, my lord, I apologize, I was at courtroom number 2. My lord, probably, my lord, subject to correction, my section 5 application is not on the record.
I do not know, that has to go. Because it is beyond the period of limitation, 170 days reading,
Yes, my lord,
So-
that's right.
and there is no application. Then we will follow that particular appellate side rules. We will return the memorandum of appeal to you. To be presented after section 5.
My lord, there's some confusion because yesterday the matter appeared in the list, that a defective endorsement was not there.
This is still a defective endorsement.
Yes, my lord, today it has appeared with a
So-
defective endorsement.
Because my court officer is also there, he knows that what I.
My lord, I'll just check, my lord,
Yes,
whatever,
defect or
my lord,
not.
kindly text it up, my lord, tomorrow or day after tomorrow, I'll just check up, my lord, the record, what is.
Section 5 has to be, if you have find it, give the number
But I'll just, my lord, go through the record once, kindly text it up tomorrow.
today. Next. Nobody is interested in the civil matter. Eight, that's my question. Who is appearing? Where is Mr. Hon'ble Banerjee? Anybody knows him? Appeal does not lie here. None appears in support of the appeal. After perusing the impugn judgment, we find that uh, the maintenance penalty was granted by the court under the provision of section 36 of the Special Marriage Act. The remedy lies by filing a revisional application, and therefore the appeal is not maintainable in view of the provisions contained under section 39 of the said act. Let the appeal be dismissed as not maintainable. Yes.
Milord, 9 and 10, Milord, I have instructions, Milord, not to proceed with the appeals, Milord.
Have you got a written instruction?
Written instruction.
Are you advocate in record?
Yes, Milord. I have
You owe the responsibility in
Yes,
the event the client comes later on and say that I never instructed you.
So, Milord, grant me 2 days time, Milord, I'll put the written communication on
No,
record.
there's no difficulty. We can record, but you'll have to owe the responsibility.
Milord, kindly then, Milord, record my submission that I have no instructions to proceed with it, Milord. Allow it to
You
go
have
ahead
no
after.
instruction or instruction. not to
Instructions
proceed.
not to proceed.
Say that. The advocate in record of the applicant submits some instruction received by him from his client that his client does not intend to proceed with the instant appeal. Next paragraph. Accordingly, the appeal is dismissed for non-proceeding. Then. Same. Yes. It's a matrimonial.
Yes,
dispute.
yes, one,
The
Milord,
right
is-
to appeal.
Milord, one is against, Milord, dismissal of the matrimonial suit. Another one, Milord, section 9 application restitution,
The restitution.
that was decreed. So against that,
So you are happy to go back.
probably yes. I don't know where, maybe the.
Any. Same order.
My lord, there is a delay of, my lord, 11 days. My lord, section 5 has yet not been filed.
Have you served? Oh, section 5 not filed.
No,
So we are returning the pen. The memorandum to you.
my lord, I will file it, my lord, by this week, my lord.
Why people are not filing it when you
I-
knew that this.
I beg of your pardon, your lordship. By this week, my lord, I will file it.
This started on Monday.
Lordship, I am on behalf of the appellant in item number 12, Lordship.
What is this application, sir? Can 1 and can 2?
Lordship, can 1 is for condonation of delay and can 2 is for
Have you
stay of the
Have you served?
Lordship. If it is hand-
of service, I am fine.
Anybody appearing for the respondent? How much? How much
Lordship,
days?
240 days delay,
Yes. 216 days.
216 days delay, Lordship.
The explanation.
My lord, paragraph 3, my lord, just, my lord, received a brief from my client, my lord.
What is the explanation?
Lordship, I'm a very poor person and I have no means to go to Calcutta, so that's the reason of my delay, Lordship, to find an advocate, Lordship. That's the sole reason, and I'm a daily wage labor, so I couldn't manage time, Lordship.
There was a, my lord, the explanation was that, my lord, the appellant was in, my lord, home quarantine.
Yes,
That was
Lordship.
the explanation.
Obviously. And when it expires. When the period expires,
Lordship,
the period of limitation expires when? Expired when?
The decree was heard on, the decree was pronounced on in the year of 2021, Lordship, and there is prolonged delay, I admit, Lordship.
In the plaint. Have you annexed the plaint?
Lordship.
Where is the plaint? Yes, at page 43. So tell us whether the appeal lies to the High Court. The valuation of the suit is 1 lakh. And the civil judge senior division has a pecuniary jurisdiction up to 1,50,000 or 60,000 nowadays. How much? 50 or 60? 1.5. Now, if it is within that original jurisdiction, whether the appeal lies to a district judge or to the High Court, tell us. Under the Bengal, Agra and Assam Civil Codes Act, where it lies.
Suit value is of 1 lakh, 1 lakh rupees, Lordship.
So whether the appeal would lie to the High Court against that. Under the Bengal, Agra and Assam Civil Codes Act. Or it has to go to a district judge. Tell us.
Lordship, the matter is relating to res judicata, Lordship, so.
Sorry? So
Relate-
res judicata, it will go to the High Court, it will not
No.
go to the district judge. Res judicata has a special
No.
charm. I do not
No,
know.
no, Lordship, no,
No.
no. As it's
Where
at
is
the
the
suit,
act? Section 21. Hey, দেখো তো Bengal, Agra and Assam Civil Codes Act আছে এখানে। You have to check before you file an appeal. একটা পাবে না দেখো কমপ্লিকেশন হয় না
Rashid, give us a date time so that we can clarify.
what
Give us a date time so that we can get back to you tomorrow.
if I get the copy of the act 5 minutes
Okay, okay.
or not even 5 minutes. You read it, but you do not care to read it. I'm not fine. You have not read it, sir. I am reading for you when you are on a virtual mode. Section 21, subsection 1 of the Bengal, Agra, Assam Civil Codes Act. It says, save as aforesaid, an appeal from a decree or order of the civil judge senior division shall be to the district judge where the value of the original suit in which or in any proceeding arising out of which the decree or order was made did not exceed 1,50,000.
Lordship.
So what more? Why you have filed it here?
Lordship, give me liberty to file before the,
Further section 5.
Lordship, let the section 5 be condoned, Lordship.
Are
Because
you aware of the, what are you saying? Are you conscious?
Lordship, otherwise it will be barred by limitation also, Lordship, and I'll be.
Read AIR 1954 Supreme Court, Kiran Singh's judgment. A
Lordship.
court which lacks inherent jurisdiction, if it passes any order, the order is a nullity. And you are inviting us to pass a order which is per se a nullity. Because we lack inherent jurisdiction. It appears that a decree passed in a suit valued at rupees 1 lakh is assailed in the instant first appeal filed before this court. Next one. Section 21 within bracket 1 of the Bengal, Agra and Assam Civil Courts Act 1887 provides that an appeal would lie to the district judge from a decree or order of the civil judge within bracket senior division if the value of the original suit in which the decree and order was made did not exceed 1,50,000. In view of the aforesaid provision, the appeal is not maintainable before this court. Hence, the appeal is dismissed as such. The learned advocate and record is permitted to take back the certified copy of the judgment and decree impugned in the instant appeal upon replacement with photocopy thereof. In view of the finding that the appeal is not maintainable because of the embargo having created in the aforesaid provision, the connected applications are accordingly dismissed.
Obliged, Lordship.
Obliged.
Next.
Let's say appear for the petitioner, Lordship. Item number 13, Lordship.
Yes,
Lordship, this is an application for compassionate appointment, Lordship.
yes,
And I'm challenging the order of the learned tribunal, Lordship, appearing at page 59, Lordship.
yes.
Lordship, father of the petitioner was appointed
No, no,
on
what
15 November
ground?
1991.
Sir, on what ground, your application was dismissed or rejected by the authority?
Lordship,
What was the
Lordship,
ground
delay.
of rejection?
Lordship, the ground of delay, Lordship. Ground of rejections by the delay, Lordship. If your Lordship kindly please to find page 59. This is the order of the West Bengal Administrative Tribunal, Lordship.
No, the original authority might have rejected your application which you assailed before the tribunal.
No, Lordship. Original, Lordship. Lordship, may I submit, Lordship? Lordship, on 15 November, Lordship, 1991, father of the petitioner joined as Krishi Somik, Lordship. Thereafter, during his service tenure, Lordship, he expired on 26 November 2008, Lordship. Thereafter, Lordship, I filed an application on 24 December 2008 before the appropriate authority for my compassionate appointment. Lordship, till from the same date of Lordship, death of my father, Lordship, the application has not been disposed of.
Has
Against
not
that,
been?
Lordship, I have referred disposed of, Lordship. Whatever my application was filed before the appropriate authority, Lordship, that application has not been responded by the respondent authority. Neither it was disposed of, nor it was rejected, Lordship. Thereafter, Lordship, I have filed an application before the West Bengal State Administrative Tribunal, Lordship. And Lordship, the learned West Bengal Administrative Tribunal, by an order dated 9th April 2019, Lordship, rejected my claim on the ground of delay that I have approached the learned tribunal after expiry of a long 10 years. Lordship, although Lordship, I applied, if your Lordship kindly see,
For a
the
direction
date
upon
of
the
father was
authority,
Lordship 26
you-
November 2008. And Lordship, I have applied
you
on
approach,
24th.
you approach the tribunal for a simple direction that your application has to be disposed of by the original authority. Is it correct?
Lordship, kindly see, Lordship. The MAO is rejected, Lordship. Kindly see the last order. Therefore, in our considered view, the main purpose of the compulsory appointment has been frustrated. We do not find any reason to condone the delay. And
Sir,
rejected my claim, Lordship.
That is a, I think, is a technical problem with the virtual hearing. Because you do not hear us.
Lordship.
I do not know whether you hear us or ignore us. We don't know. But you are not responding to our queries. You are continuing in your own
No, Lordship,
flow.
Lordship. Lordship, Lordship.
Sir, I am
Lordship.
saying that your case was that the application for compassionate appointment, which was filed in a very close proximity of the time of the death of your father, was kept by the authority in the file and did not take any decision thereupon. Being perturbed or disturbed by this inaction of the authority, you approach the tribunal for a direction
Lordship.
upon the authority to dispose of that application. This was your
Lordship,
case.
Lordship.
And but the tribunal has
Lordship.
proceeded to decide the matter on merit, saying that 10 years have
Merit, Lordship.
expired. This is what?
Lordship.
I
This is
think
my
a
case,
good
Lordship. This is my
lawyer,
case,
a
Lordship.
good lawyer will not take 30 seconds to say so.
Actually, Lordship, there is some virtually some technical problem
Can
is
you,
there. Lordship,
sir,
this is my
tell
case,
us?
Lordship.
Can
Lordship,
you, sir?
absolute right.
Where is the service? Oh, somebody, Mr. Devobroto Dhar.
Yes.
And Mr. Paramita Sahu, Miss Paramita Sahu. No, anybody knows?
He's the former AG.
Now who is now representing the state?
Now, Mr. Sumit Shah is the AG.
Call him.
Gotcha.
Keeping a copy before the matter is or the file is handed over to a AGP or anybody who says the copies are given. So one is for the senior, one is for the junior. No, are you not keeping for your office purpose a single copy? I think your system is faulty. You have to correct your system.
This matter, this system is not followed even in the principal record. 2 copies are received, 2 copies are given to the.
That is what is the problem. And this is what the you people's come, now there is a change, he's not having,
No, my lord,
and the
the
matter
problem
is
is that he has-
just running in the list
From the,
for no purpose.
from the alert department.
Do you have any person here, Mr. Bhattacharya? I do not know whether he's a Kunaljit Bhattacharya. What is his name? Mr. Counsel for the petitioner,
Lordship. My lord,
have you got anybody here who can serve a copy of your application to the state?
Lordship,
You are
Lordship, my clerk is
advocate
there,
on
Lordship.
record. Who is your
Lordship,
advocate?
now it is, now Lordship, it is changed brief, Lordship. Myself is the advocate record, Lordship.
And why don't you come here and do the case? If you are an advocate on record sitting in Calcutta, how? I am suggesting that there must be an amendment in the rules. That a person who is not within the territorial jurisdiction of the district of Jalpaiguri will not be permitted to file an wakalatnama. Will not be permitted to file wakalatnama. If the copy has to be served, they have to rush to Calcutta to serve you a copy.
No, Lordship. My
Then-
clerk is there, Lordship. It was served, Lordship, at
Where is the
earlier
clerk?
occasion, Lordship.
How you will give him a copy?
Lordship. It was, Lordship, earlier occasion, it was also appeared, Lordship. My
Now, he
impression
says
is that,
there is a
Lordship,
change of the panel. The earlier
Lordship,
AG
Lordship.
no longer there. Now he has been appointed. And he says he has not given a brief. They will take care of that situation. They will take action if the law warrants that. But if you give him a copy, it can be disposed of. How
Lordship,
can you give him a
kindly,
copy? Tell me.
Day after tomorrow, Lordship.
Sorry?
Day after tomorrow, Lordship.
I
I'll
just
serve.
wanted to know how you will give him a copy.
Lordship, I will send, Lordship. I'll send through post, Lordship. Through special messenger to my clerk, Lordship. And Lordship, he will just serve the learned advocate for the AGP, Lordship. And the appropriate person, sir, who is appearing for the Lordship state, Lordship, I'll serve, Lordship.
I do not know what he says. Gone beyond.
What he's proposing, he will be sending it by post.
I am fixing this matter on Friday. If you do not appear in person before us, we will dismiss your application.
Lordship, I will appear, Lordship.
There is no representation
Great,
on
Lord.
behalf of the state. However, the additional government pleader appears and submits that he has been recently appointed in such post as the erstwhile AGP is no longer interested in representing the state. However, he submits that the copy of all the files which was lying with the erstwhile additional government leader has not been handed over to us, and therefore showed his inability to proceed with the matter. In order to obviate such impasse having been created, for which we cannot find any fault into the petitioner, yet in order to render justice to the litigants, we direct the advocate on record of the petitioner to serve a copy of the instant application, the writ petition upon the learned. What is your good name?
Subir Kumar Shah.
Mr. Subir Kumar Saha, the learned additional government leader. By Wednesday, by Thursday. Let's list this matter on Friday.
Great, Lordship. I'm grateful.
Yes. Call the next matter.
My lord, 49, I appear for the petition, my lord. My lord, allegation under section 4579.
Lordship, short passable, Lordship. Short
Why?
passable.
Why?
For bring the city, Lordship. City already received, Lordship. Short passable, Lordship.
My lord, I'm in custody for 68 days, my lord. Other 4 accused have been granted bail by the court below, my lord.
Court below.
Yes, my lord. My annex 1 order, my annex P2, my lord. P1. And my lord, on 22nd July, other co-accused have
1
been
minute.
also granted. Yes, my lord. Yes.
Which page? The
My lord,
co-accused have been granted bail.
my lord, page 9, on order dated 30th May 23.
There are 2 orders.
My lord, I have annexed the other order also. Annex P1, page 9. Vinit Gautam, Abhishek Gautam. Yes, ma'am.
Yes. Yes.
My lord, another co-accused have been granted bail on 22nd July 23, my lord. My lord, that order is not annexed, my lord.
That order is not annexed.
No, my lord.
How
I
do we
received,
know? It's
my
not a
lord, I
part of the
received.
record.
My lord, it will be a part of the case diary, my lord, I hopefully, but my lord, my junior is there. I've sent it in the WhatsApp, my lord. If she has taken the printout or not, I don't know.
Yes. What is his name? Other co-accused?
Yeah, other co-accused is Nima Lama. Nima Lama.
Himala. Okay.
I'm in custody for 68 days, my lord.
Good. Yes. Anything more, madam?
My lord, this is I'm claiming parity.
What is the stage of the whether the charge sheet has been filed or not? It's a stage of investigation.
Stage of investigation, my lord. As far I didn't receive any information regarding charge sheet, my lord.
You have not received any information.
No, my lord.
Yes. There is only ground of parity.
When the other persons who have been granted bail, they are the customer, my lord. I'm also a customer to this means.
Where you have stated.
Well, it has not been stated in the paragraph, my lord. It has not been.
How do we know unless you say something on affidavit?
Well, then
mere statement at the bar is sufficient. Tell us.
no, my lord, that is not.
No. Anyhow. Yes. The instant application for bail is taken up by the minister being a co-accused in connection with the aforementioned case registered under immoral trafficking, traffic within the Prevention Act 1956. The aforementioned case was registered on the arrest fact that the minister along with the other persons are running an illegal trade of prostitution and transporting a girls against her will in consideration of money and the proof of mountain for the court. Learned advocate appearing for the petitioner submits that 3 of the co-accused have already been enlarged on bail by the ACJM on 30th May 2023. It is submitted that the petitioner, standing on the same footing, should also be enlarged on bail. It is submitted at the bar that the petitioner is also a customer and have been implicated in connection with the instant case. Next one, the learned advocate appearing for the petitioner considered that the factum of being a customer has not been averred in the instant application. The court will not go by a ipsit dixit of the submission made at the bar without any foundation in the pleading. The present application is required to be considered whether the petitioner stands on the same footing that of the other 3 co-accused who have been enlarged on bail on 30th May 2023 by the ACJM. The certified copy of the order sheets concerning the instant case is annexed with the instant application. We notice the order dated 30th May 2023, wherein 3 co-accused, namely Vineet Gautam, Abhishek Gautam, and Iqbal Ahmed, asking were granted bail. As it was found that they were mere customers, having no involvement into the immoral trafficking of the girls or forcing them to prostitution. The first sentence of the said order would indicate that the name of the petitioner that the petitioner, along with the other co-accused, were represented by the same lawyer, and it was indicated that the petitioner stands on a different footing that of the other 3 co-accused, meaning thereby the prayer for bail sought for by the petitioner was rejected. Furthermore, the court, in the latter part of the order passed on the said date, reflected the statement of the victim girl and upon taking into consideration the gravity of such statements, passed several orders upon the authorities to take adequate measures in this regard. the person can seek parity only on the grounds, seek parity only when he stands on the same pedestal that of the other. So a little variation or a difference in the status of the person and the role attributable to the commission of the offense may put him on a different footing than the different footing that of the other co-accused. In absence of any categorical statements that the petitioner stands on the same footing that of the three other co-accused, we do not find any merit in the submission of the petitioner that the petitioner deserves the equal treatment with the other co-accused. The equality amongst the equals are the hallmark of the fundamental principles enshrined under the Constitution, and not equality amongst the unequals. We thus reject the said application at this stage.
Grateful.
The learned advocate on record on behalf of the petitioner, my lord, is out of station for some treatment purpose, my lord.
For the what?
So, my lord, it will be on, my lord, Friday or
Friday. Yes, sir. Sorry.
Yesterday, another co-accused granted bail by your lordship.
Co-accused granted bail. That gives an impetus to you to take out this application immediately.
Before that, I filed today.
Before that.
Lordship remembers yesterday, Mr. Bhomik moved the application. Two persons were apprehended with the contraband from Bihar. The vehicle was of Assam and the owner was of Assam. He was not apprehended the same. The other accused was granted bail and he's.
What can be done? The same treatment to them because of the Supreme Court judgment.
That is it.
4 years.
Lordship, Sanjay Kumar, the yesterday the accused was
How much?
Sonaj Kumar.
4 years.
Only.
4 years.
Nearly or more than? Yes. The name of that?
Lordship,
You have a
Sonaj.
CRM number?
Yes, sir. PRM indicates 4/4/2020.
Sonaj Kumar.
Stand on the same footing as earlier.
Sonaj.
From your
Sonaj Kumar. SONAJ. Sonaj Kumar.
by one or two on the basis of the order.
444. Grateful, Lordship. Your Lordship, I'm for the petitioner. Bring for not press, Your Lordship. Not press. Your Lordship, the petitioner wants to not press the matter. Petitioner wants to not press the matter.
Not fair.
Your Lordship.
My lord,
Your Lordship.
my lord, may grant me 1 minute, my lord. Lordship, I was wondering only one aspect, whether a bail petition is maintainable before this honorable court, while another bail petition is pending before the court below. The petitioner has already availed a bail petition before the learned session judge, and same time he comes before this court. Let this be dismissed, my lord, on the ground of suppression.
What you say is.
I'm not pressing the matter.
My lord, he is withdrawing the case.
Yes.
And he has suppressed this fact before this court that he has already filed a bail petition. During the pendency of that bail petition, he has come up.
Your Lordship, I'm not aware.
Anyway, he's not moving this matter. He's withdrawing it. Okay.
And there, after knowing the fact, I'm praying for not press the matter. Your
I
Lordship.
tell you very clear. I have been very critical in one of the judges. When I am put cost against a particular lawyer, 50,000. Because he was doing, what he was doing is that he was frequently filing the bail application during this pattern. And he was taking charge because there were the different benches at that point of time. One is rejected.
Lordship has got my point.
Just to get a chance that if one bench is liberal, he gets a bit. Fortunately, the third one came before us, before I was sitting with another judge. And then it was brought to our notice that earlier to us, we have post part. Now, here, he concedes that yes, there is. There, he wanted to move it. Argue the merit.
See, we are always considering these chances. But we don't get a chance.
Advocate for the petitioner. Absolutely, sir. That is right. Yeah.
Grateful, brother.
If we move on merit, we could have. You are correct.
Grateful, brother.
What time for the petition?
Don't know that.
My lord, in compliance of your lordship, my lord, direction, my lord, I inform my client, my lord, the certified copy has yet not been, my lord, supplied by the learned court. And my lord, so, my lord, so far my verbal instruction is concerned, my lord, the investigating officer and the, my lord, the doctor is, my lord, left for, my lord, only 2 witnesses is left for examination. Other charge sheeted witness, my lord, has been already been examined. And several date has been passed, my lord. This
we can only say to expedite, but we wanted to know whether there was, you have, anybody who said no.
No, my lord.
Next date have you?
Yes, it was fixed on 7th of July.
bail is not there.
You were supposed to file the certificate copy.
You are supposed to go from the line.
I don't know, then have to talk with the PP at the lower court. No, no, madam, that.
You could have talked to the IO immediately.
My lord, only
They are
my,
you-
my
contact
prayer is
you.
that, my lord, only 2 witnesses, 3 witnesses are left.
No,
In that case, my lord, that, so at this stage, bail application.
Because you have to complete the trial from the date which is already fixed.
The medical officer and the magistrate is left and the IO.
Each schedule of evidence.
That I'll inform.
That is what I
Five,
wanted.
5 minutes, madam, 5 minutes.
We'll expect it, don't worry.
19, I am appearing on behalf of the petitioner. Your Lordship, in this matter, the allegation is under section 395, 397, 396, adding section 216A and 412, your Lordship. The petitioner was earlier on bail, your Lordship. During pandemic, he could not abide by the obligation he had, and eventually he was again arrested, your Lordship. Your Lordship, I have annexed the deposition
Earlier
of the complaint.
petitioner was granted bail.
Yes, your
Where
Lordship.
is the- where is the order?
That I have not annexed, but earlier occasion he was on bail, your Lordship, and moreover, I have annexed the deposition of the complainant, that is the PW to your
Anyway,
Lordship.
it
Even
was on bail, that order is necessary. And when did you fail to appear?
before the Mathabanga, your Lordship, before the Mathabanga Sessions Court, your Lordship. Your Lordship, even all other depositions, his name has not been transpired, your Lordship. That paper I tried to collect, your Lordship. I have applied for the certified copy of those depositions as well, your Lordship. Your Lordship, even from the other depositions, your Lordship, the trial has already started, your Lordship. The name of the present petitioner has not transpired, your Lordship. I have filed for the. Lordship, kindly consider, even I have annexed the document, medical document.
Persons are absconding.
Yes, your Lordship, but
So trial is commenced, the trial is continuing.
yes, your Lordship, and 10 other persons are already on bail, your Lordship. They,
Another persons already on bail.
yes, your
So how many
Lordship.
accused persons are there?
12, your Lordship.
So except the petitioner and the another accused, all are on bail.
Yes, your Lordship. Kindly consider. During the pandemic, due to work, due to livelihood, at any stringent condition, your Lordship.
Notice this fact and refuse to grant bail. What is now changed circumstances that we have to take a different view. The same thing happened.
Your
Same
Lordship, the
thing that during the pandemic, you were compelled not to comply. This was available to you. You might
Lordship.
have taken, the citizen did not find it sufficient enough.
Your Lordship, on the ground of detention, I'm praying, your Lordship, kindly consider that. Your Lordship, kindly consider the last rejection was on February, your Lordship, and since then, today we are on August, your Lordship. Kindly consider that, your Lordships.
The PP, what is that? Your office has no information. Is only a recipient of the papers, nothing more than that. Nobody is applying its mind. not take instruction from the IO when he came and gave it, repeated information. No, when he came and handed over to you the CV, will you not ask that, please tell us and make a note, what is the stage of the trial? Madam, how many witnesses are there according to your client's instruction?
Your lordship, that even I do not have, your lordship. That even I do not have that specific instruction, your lordship. He started.
So take instructions and come.
Number two, tell us.
Your lordship.
Yes, ma'am.
Yeah, allowed, I think.
No, my lord.
The only thing is whether sample has been taken. Yesterday, somebody handed over that order. Who is appearing for the witness?
This is the report, my lord. Present status, last page. my lord.
Give us this status of third.
The next date before the trial court is scheduled to be held on 9th of August, Lordship, for supplying of copy. Lordship, may I just pray for adjournment of this matter for the next circuit, because I want to move this matter after getting the copy of the prosecution story, Lordship. File charge sheet has been submitted, Lordship. Now the copy is to be delivered on the 9th. The copy is to be scheduled to be delivered, Lordship.
There is sufficient material.
That's true, yes. The charge sheet, that means there is a sufficient material copy. We wanted to move it. How it will improve your case.
No, I don't know what is the material against me, Lordship. That's why I need the copy. The copy is scheduled to be delivered on 9th. Lordship,
When you find the charge.
charge sheet filed, Lordship, on
Charge sheet filed on 8/6/2020. The next.
July and all for giving the copy.
the next
There
date
is
is
Within a close proximity of time, within a week. It's only handing over of the copy.
In the lower court, it fixed the date for the supplying the copy.
Absolutely acceptable that after a gap of 2 months for handing over the copy.
Lower court, it fixed the date.
will make certain observations. We are keeping this matter on Monday. Just in the weekend, you can take the copy. Either a lawyer's letter communicating the whole of the text of the order or a
I will bring the certificate.
where the charge sheet has been filed and then the next date for handing over the paper.
No, there is a process, Lordship. May I say the Lordship, there is a process under section 200, that after filing of charge sheet, Lordship, if the accused was absconding, there was a requirement for initiating the independent process of proclamation, attachment and no, because all are, this is post charge sheet and comment prior to commencement of trial, there is a process. So
He's already invested at the charge sheet and after the investigation, the charge sheet is filed. He's not an absconder.
No.
So that is his right, not only under the statute, but under the constitution to get all the papers.
exactly.
So why the court will fix a date 2 months or 3 months after the date of receiving the charge sheet for handing over the papers to the why? It is that should be done immediately. That shows something else. You have to make that out.
Lordship.
You are aware when somebody is responding.
Lordship. On Monday, man.
Yes, you can,
I will get the certified copy or order sheet.
or whatever. But we want the full text of you. So that is. Or. 24.
Please.
Yes, ma'am. Yesterday.
Yes, ma'am.
For permission you wanted an act.
Yes, ma'am. I will. Madam, there are 4 directors of the company. 2 of the directors, after filing of the charge, they filed a criminal revisional application for stay of warrant. They filed criminal revisional application before the Honorable High Court. Honorable Civil Judge directed the stay of the warrant and the surrender before trial court. Immediately on that day, they granted it. I annex court order and the trial court order also.
But you did not file a criminal.
No. Did not file the criminal revision, but there are 4 directors and all the directors in this charge sheet. If your lordship kindly see the charge sheet, my lord.
Now the question is the misprision by who? Which director? 2 or some other?
Misprision, all the directors have to do. There is no mal. No, mal.
There are.
No, my lord.
No.
No, kindly see.
No.
Kindly see the charge sheet.
Under the Companies Act, what is the
Yes.
role?
Correct.
Directors?
Under I have taken company segment of all the directors are the same. In this case, in the incident, I am not the there are several kind of director. I am not the all are active directors.
Kind is different.
All are
You are thinking of managing director.
kindly see the charge sheet. Kindly see the charge sheet, my lord. What is going on? Kindly see the charge sheet.
No, apart from you, how many accused persons are there?
Apart from there are 4 accused
Who
persons.
are granted bail?
There are 4 accused persons. I have specific instruction, my lord. 3 are enjoying liberty of bail. I am in.
You said 2.
But I have the order. Thereafter, I oral instruction. Another also on bail, my lord. Yes, my lord. And I am in custody about 234 days, my lord. I suffered custody on the same duty, my lord.
What company?
But company
What
means
is this company?
company is, my lord.
No. What is the?
Yes, my lord. Unifying, my lord.
Handicap Share Broker Limited.
Unifying.
I
Well-
was expecting that from you.
Well, unifying in cap share broker limited. Kindly see the chart sheet for
Share brokers limited. My lord, kindly see the charge sheet. Are you a registered share broker of the NSC or a BSC? Yes, my lord. My lord, kindly. My lord, kindly. My lord, kindly see the charge sheet. What is the role differentiated by those on bail and my quantity? Can you see? They submitted the charge sheet. My lord, I have 50,000 shareholding. That is my brother. Yes, sir. Can you see? Can you see? The charge sheet, my lord. They are on bail, my lord. They immediately surrender and they granted bail and there is stay over. But magistrate tribunal office, all are maximum 7 years imprisonment, my lord. Can you see? This is the charge sheet, my lord. What is the differentiate goal, my lord? How you are moving a contempt here, this main application for us. Another is, if it is. Yes, my lord. My lord, another section, only, my lord, only one section. Only one section they added, section 409. Yes, my lord. This is not applicable in instant case. I am not a public servant.
Charge sheet is submitted under 409.
Yes, my lord. Can you see the charge sheet for a moment, my lord? What is the differentiate role, my lord? They, my lord, case was registered in the year 2013. My lord, kindly heard me. And Supreme Court passed an order. All the chief fund cases will be initiated by the CBI. And CBI took up the investigation in the year 2017. And they submitted charge sheet in the year 2019, my lord. And they saying that selling of certain property. And during course of investigation, they did not attach the property. And after submission of charge sheet, and all, my lord, use the word experience. No, my lord, kindly see, my lord, company sells the property. I am not selling the property. My lord, kindly see the
When
paragraph.
was your bail last rejected by this court?
Not high court. my
Oh,
lord.
you did not move to high court.
Ask the application, my lord.
You are in
Any
custody for how many days?
Sir, I am in custody about 234 days, my lord. If your lordship kindly. Sir, tell me how 409 is restricted to a public servant only. Yes, my lord, kindly see. Please. Yes, my lord. Tell us. I have a section. Yes, well, I have taken. Yes, please. Yes, my lord. Read this. Yes. So, valiantly said. So let us. Well, criminal breach of trust by public servant or by banker, merchant or. Yes, you are doing the. You are acting as the agent of protest. In this case, what happened? Kindly allegation, in this case, what is the allegation? What is the allegation? I take it. Certain people, deposited certain amount, they did not receive the amount. This is the allegation. This is the allegation. This is of the complaint. And this is the allegation. Yes, my lord. Yes, my lord. I am not complaining that there are 4 persons. 3 are on bail. Kindly see the charge sheet. If they find an NBSC. My humble submission. Kindly see the order passed by the Honorable High Court. When they did not join in the investigation, they simply filed a criminal divisional application, stay of warrant. They granted bail. They did not take it into custody.
Yes, are the allegations against the persons who are on bail
Yes, my lord.
same against this
Yes,
person?
my lord.
Allegations are different.
Criminal allegations are there. My lord, kindly see. My lord. He has grown up. His energy level. My lord, kindly see the charge sheet page number 22. My lord, kindly see the charge sheet
Page
page.
22.
Charge sheet page.
Yes.
Certified copy of the charge sheet page 22 para 16.34. Amount of the director who received this amount. What amount taken by the director? My lord, can you give the copy?
16, page 31.
Page 22 of the charge sheet.
Page 22.
My charge sheet certified copy. My lord, can you give me one second, but I think. Hold it. My lord, kindly see paragraph 16.34. And if your lordship kindly takes up paragraph 16 point, charge sheet saying, my lord, I am not saying, my lord. The investigation authority is saying, my lord.
16.23.
Yes, my lord, 16.2, page 17.
Yes.
Yes, my lord. If your lordship kindly peruse all those paragraphs, 16, page 17.
16.24.
Yes, 2, 3, 2, 4, all these paragraphs, your lordship peruse. The involvement are similar, my lord. Charge sheet saying. Your lordship kindly see the charge sheet. And one of the person, Pritish Bakshi, who can get bail one day, he has the shareholding of 50,000, 15,000. I also the 50,000. And amount received only 50,000. Well, kindly see the role in the charge sheet, my lord. All are in similar circumstances.
Yes, let me hear from.
Yes, my lord.
Advocate for the state.
Yes, my lord. Another thing is that, my lord. This is the judgment passed by the Honorable Advocate Court, my lord. Not Sharas matter, my lord. তোমাদের relying this judgment in another matter, I was granted 20 similar. In the case that matter, in the case of heat fund, there will not be done. No, this is not this thing that matter.
Who say why you have this impression in
No,
your
no,
mind?
I have no impression, my lord. 3 are on bail.
That's true.
I only one person, my lord. In the charge sheet, my lord, they are not reported. In the charge sheet, if your lordship peruse, I have the similar role. I have given the charge sheet, my lord. His judgment was relied by the honorable judge. His judgment says that bail is the rule. Bail is the exception, my lord.
Yes.
Well, and it's the tribal offense. I mean, suffered custody, if your lordship granted any stringent condition, I will comply. And another thing is that in chief fund case, our High Court observing that property will be attached and selling, they will get the amount. This is the, I mean, in Ponzi matter. Yes, madam.
Yes, he has sold the attached property.
Attached property, how? He did not take up getting the argument.
But on your added the sales document. He has already received 41 lakh out of his own bank account.
Where do I which okay. This is the date. Date 20. November 2020.
After filing.
After filing.
Page 90. Index. Which actually profit. Yes, 20 lakhs 50,000. What was the state? The constitution only shows this no, this these you showed it actually quickly. What is the consideration money? And what about the rest amount? Oh, there is another entry. So saying the 20 lakh 50,000 means 41 lakh. And the rest 59 lakh they didn't get. So the deed. What is that? Well, I just wanted memo of classification is there. So my lord, there are 4 deeds. Add up to 80 lakh. Out of that is 49 and the purchaser is one. Same as well. Three is same and one is not. One is doctor, three is doctor stands to one and one is not. So my lord, the agency coming up with the supplementary. And he's representing as the, he's representing the company without the other directors having joined there. So I find from the history of it, is only he who has been. And the order of attachment was passed when. They came to the head and did warrant of this state for an immediate period and the honorable court gave them ideal court. You go and surrender a obtain bail, but this fact that I am including now before my order was not there. They never sold any other. And received the money on account. You know, money from the state. Thank you. Yes, withdrawn, yes, withdrawn 5 lakhs, withdrawn 5 lakhs sell. From a company's account or in a personal account? Yes, personal account. I don't get the name of all other. No, this is the bank account of a company or a personal. No, it's personal account. Why not the form left hand corner also will find the name of the account holder. Aadhaar will be. Account belongs to the Union Bank. All of the money belonging to the company will go to the account of a company. If $100 was sold by the company, then it has to go into the bank account of the company. Yes, sir. Anything more?
Lordship, so this is why we are opposing the bail, my lord. That he is at selling the attached properties that to below the government set for value.
What, when the attachment was
No, my lord.
closed anywhere?
Charge sheet, nothing. They
Lordship.
are I have been 35 copies of the charge.
Is it necessary to disclose?
They show whether this party was attached and
Why you have kept in your personal account, sir?
not
Why?
personal.
Sir,
State agents. State agents.
sir, I am asking you, you are representing as a director of a company, and a company is a vendor in a deed of sale.
Yes, ma'am.
And the money is deposited in a personal account of a person. It's a further, I do not know what they will be doing. They have to take further decision on that, how you have routed the money.
Lordship, we're coming up with a supplementary chart. And my lord will also see there is no resolution, no seal used, but holding himself to the director of the company has sold.
Case 16 of my application.
Yes.
One, 15 vaccines, filed an application. And there are in the next phase.
Prithvish Bakshi did not sell.
Kindly speak, kindly heard me, Malak. They never.
What do you think that we are not hearing you? We gave you an opportunity, full opportunity of hearing.
2 minutes.
Yes.
Not more than 2 minutes.
Yes.
Yes, Malak. All the 3 directors, they granted. In the
We have heard you, sir. This is the 7th time you are repeating.
Yes, my lord. Yes, my
Yes.
lord. Yes,
We'll take care of that.
Yes, my lord.
Permit us to dictate
Malak,
the judgment.
not more than 1.
Yes.
They never opposes their prayer for bail before the court below. And in the charge sheet, they never said that there is distinct role with me and the other director.
Correct.
Another thing. And another last thing is that I already suffered custody 234 days. If I remain in custody, what will think? And my thing is that, my lord, I will cooperate with the investigating agency with any stringent condition. I will cooperate with what they want. My lord.
Yes.
I have no objection to their condition. Another thing is that, my lord, and another thing, my lord, case was registered 2013. Supreme Court passed an order 2014. They registered case 2017. And 2019, they submitted charge sheet.
Yes.
And they saying that they will file a supplementary.
Yes.
And it will take how much time?
Yes.
There is remote possibility of commencement of trial also, madam. Other on bail, enjoying, I will cooperate with the investigating agency in any stringent point.
Yes.
These are my points.
Lordship, this information would have been obtained only after he was arrested, brought under an arrest of warrant. And after we took him into remand. We have to find out where the rest of the money lies that he received in cash.
Yes.
80 crores has been defalcated, my lord.
Yes.
So, my lord, we strongly oppose the prayer for bail. And the bank statement that we have submitted before my lords clearly fortifies application of section 409.
Anything? That's all?
Yes, sir.
Thank you.
Market value 60 lakhs, so it is 20.
How many witnesses you have cited? Sir?
Lot-
40 or 50? 36. The steps have been taken in this, that is being tried in the CBI court.
Lordship,
So any steps is being taken after the filing of the charge.
Lordship, as soon as we unearth this information, we are trying to unearth where the money has been routed, and we are filing a supplementary charge sheet.
I think another ground, as on today, the court what should be. Yes. The prisoner has been charged with the economic offense. Being one of the director of the company. Who is involved into financial disability of the in the society. Having great impact on the sustenance and the aspiration of the poor or the marginalized section of the society. The company have received various deposits and misused and abused the same, which led the registration of the case under various sections of the penal court, including section 409, and ultimately by an order of the Supreme Court, the entire investigation was entrusted upon the CBI. The charge sheet has been filed on the basis of the act of the company and its directors. And it is a specific, it is a categorical stand of the CBI that they are still proceeding to unearth various aspects where the monies have been diverted by the director or any one of them from the company's account to their personal account. The moment the CBI have taken such stand, it emboldens the present petitioner to contend that out of 4 directors, three of them have been enlarged on bail. And therefore, the present director is standing on the same footing that of the other director, cannot be denied bail on the ground of parity. When the instant application for bail was moved before the earlier division bench on 31st July 2023. No, sorry, on 14th July 2023. This court directed the CBI to submit the report in the form of an affidavit disclosing the various disclosing the facts attributable to the conduct of the present petitioner. Full stop. Obviously, the aforesaid direction was passed on the basis of the submission advanced before the earlier division bench that the role and the conduct of the present petitioner is such which disassociate him from the role and conduct of the other director. Yesterday, the matter was taken up and the CBI files a report in the form of an affidavit disclosing the documents unearthed during the investigation concerning the present petitioner. It is disclosed in the said report that despite the investigation having been taken by the CBI on its shoulder in terms of the order of the Supreme Court and an order of attachment having passed in respect of the various assets, properties, and the other movable or removable property belonging to the company, some of the immovable properties of the company has been sold, transferred, and conveyed by the present petitioner. And now, which would be revealed from the certified copy of the sale deeds executed by the petitioner as annexed with the said report. It is vociferously submitted by the CBI that the consideration money disclosed in the purported sale deeds have been diverted to the account, to the personal account of the petitioner, which would further be evident from the statement of the accounts handed over by the respective bank. The counsel for the petitioner relies upon a judgment of the Supreme Court rendered in Satyendra Kumar Antal versus Central Bureau of Investigation and another, reported in 2022, volume 10, SSC, page 51, for the proposition that the court, in relation to an economic offense, cannot overlook or bypass the provisions of the court. More particularly, section 41 and 41A of the Code of Criminal Procedure. And detention should be avoided unless necessitated by competing circumstances. Even a division bench judgment rendered in case of Assis Dhar, within bracket CRM, within bracket TB 435 or 2022 is relied upon, wherein the division bench on 9/3/2023 granted bail, taking into account the judgment of the Supreme Court. First off, the first and foremost point involved in the instant application is whether the petitioner stands on the same footing that of the other directors is required to be dealt with first. It's no doubt true that the company is represented by its board of directors, who are in the helm of affairs and collectively responsible for any action of the company. Either jointly or several, depending upon the facts of each case. The company is represented by its board of directors, and therefore any action taken by them in relation to the company would make them liable to be treated at par with each other, as it is a decision of the board of directors responsible for the commission of an offense, be it economic or otherwise, in relation to the affairs of the company. We have given to understand that three of the directors moved the court with the criminal revisional application, selling the warrant of arrest, which was disposed of with the categorical finding that they would surrender before the concerned court / magistrate. And in the event they are granted bail. In the event they are granted bail, they would enjoy such immunity. Obviously, the petitioner was not party to those proceedings. It is revealed in course of the investigation that the petitioner, representing himself to be a director, sold, transfer, and conveyed the immovable property of the company, claiming to have been authorized in this regard. And astonishingly, the consideration money is deposited in a personal account of the petitioner instead of the account of the company. It is further revealed from the statement furnished by the bank concerning the personal account of the petitioner that a sizable amount of money has been withdrawn therefrom and obviously being utilized for their personal use. The opposite action of sale of the immovable property is on the teeth of the charge sheet having filed before the concerned court. And it cannot be said that the petitioner was unaware or not conscious of the fallouts of the aforesaid submission of the charge sheet. The apex court in Ash Muhammad versus Shivraj Singh, alias Lalla Babu, and another, reported in 2012, volume 9, SSC 446, has held that even if the period of detention is considered to be one of the factors to be weighed to the court, but such factor cannot be taken in account in isolation to the other circumstances. And it is a duty of the court to strike a balance between the individual liberty and the impact on the society. It is further held that the economic offense constitute a class apart, and a different approach is required to be taken in the matter of bail. The reason is obvious that it has founded upon a deep-rooted conspiracies involving a huge loss of public funds, not only impeding the economic development of the company of the country, but also have a ramification on the financial health in Satyendra Kumar Antal. The apex court has indicated the exception required to be taken in relation to an economic offense for the purpose of bail. It is succinctly highlighted that a fine balance is required to be made between the nature of the economic offense and the period of detention. suffered by the under trial. There is no quarrel to the proposition of law laid down in the above noted decision that a court must bring an equilibrium between the nature of the offense and the period of detention, which should not be construed to have its application in abstract form, as every economic offense has its unique modalities and therefore has to be judged on such parameters. The role and the conduct of the petitioner in the instant case is apparent and evident that despite having a knowledge that offense, that the case has been registered for an alleged economic offense and the charge sheet has been filed, the petitioner sold, transferred and conveyed the properties of the company and used and utilized the money, used and utilized the consideration amount for his personal gain, having deposited in his personal account, which cannot be viewed leniently. The diversion of the assets of the company during the investigation, more particularly after the prima facie evidence is found in relation thereto, cannot be brushed aside, nor the courts should view the same. In the perspective of the monetary irregularities. To stop. The economic offense, it stands on a different footing than of the monetary irregularities. Without having not affected the society at large, more particularly the poorest strata of the society. In view of the role and conduct as exposed before us in the report concerning the petitioner, we do not find any material that the petitioner should be treated at par with the other directors. There is this court has reasonable apprehension supported by a corroborative materials that in the event the petitioner is released on bail at this stage, that there is a possibility of further abuse and misuse of the assets of the company. And the honest and the bona fide depositors would be deprived of their just due / claim. The application for bail is rejected.
Welcome, my lord.
Let's call the next.
My lord. This is a case under section 357, 370, 370A, read with section 3, 4, 5, 6, and 9 of Immoral Traffic Act. The petitioner is a lady who is in custody for 3 years, 10 months with a lady, with a girl child in lap.
With the girl child?
In lap.
In lap.
Ah.
In a
In a lap.
How old?
5 years. 5 years now.
Not in the lap.
Now,
Not in the lap.
when he was taken into custody, then he was 1.5 years. And till date, only one witness has been completed, Your Honor. Nowhere his name has came, not in the FIR, not in the,
Then how you are?
no, in the, his name has been,
Charge sheet your name. appears.
yeah, in charge sheet, because in the subsequent charge sheet, because one of the accused, co-accused named her in your statement. to the police.
164 statement, it was not there.
No, not in the 164 statement, not in the evidence of the VG, not in the evidence of the second witness, that is the complainant.
You did
Not in the
apply for
complaint.
bail earlier.
Yeah, I have filed, but it has been rejected, Your Honor. One of the accused, the prime accused is in bail on the ground that his name has not come in the evidence of VG,
By whom?
but the trial court.
Trial.
Is in the same footing, 3 years, 10 months. my lord.
How many witnesses have been examined? One.
Only one has been partly, and 11 witnesses more to be examined.
So it is pending from 2018.
2018, my lord. The complainant deposed in court, she clearly stated only 2 ladies involved. Their name has been stated. Nowhere his name has come. Not in the 164, not in the FIR, not in the deposition of 2 witnesses. This is the first time he is praying. He's a very, from the lower strata of the society, first time.
This is the victim girl.
Yes.
Victim girl. She did not disclose his her name. He saved one gentleman and his wife.
That gentleman died in custody for this long period.
Lordship, in her evidence, that one lady, she identified the lady on face. Lordship, TI parade was held, Lordship, and those lady was identified in TI parade, but unfortunate, those chapters not revealed in the evidence, Lordship.
What can be done? Why should she remain in custody?
See, 2018, the case is going on.
Petitioner name transferred in the supplementary charge sheet, Lordship. This petitioner identified, this petitioner identified TI in TI parade, Lordship.
But in the disposition, the victim lady did not disclose. I'm using the word lady because I find she's major.
Yes.
She never disclosed her name.
And name transfer on the statement of the co-accused.
I'm asking whether.
Yes, Lordship. In the deposition.
The deposition, she identified.
Lordship, after the deposition, thereafter the supplementary charge sheet.
But a victim lady who is the victim of the circumstances, she must be identified. She knows that who is the lady who is. She's
When she deposed at that time, this petitioner was not arrested.
not a question of arrest, it's a question of disclosure of the name.
She did
How-
not
how
know,
she did not arrest?
she did not know the name of those ladies, Lordship.
Why? That's why I'm asking. If she does not say anything in a.
This lady fled away from her home to Guwahati railway station.
I have seen, that's the most social problem because she has narrated that how she was really being treated in the house by her father. She has narrated those, vividly narrated, but when she narrated all the incidents, he named one gentleman and his wife. She is not his wife.
No.
If she has not disclosed the name, then
This lady and another lady, they brought the victim girl from Assam to Siliguri and sold this.
correct. So a victim maybe while undergoing this particular journey does not know the name of his lady. At least some nickname, something.
On what
Some
basis?
subsidy driver.
You can sustain.
In 164 statement,
One-
it was two lady in 164 statement.
when the evidence has taken.
Yes, yes.
Whether the 164 will have
Yes.
the primary, only to very limited extent, you can need an evidence to just extract the portion thereof where the admission is. Nothing more than that. It is the evidence which will prevail. The evidence does not say it. Then why she should be put in custody? On the spot that her name was neither disclosed in the FIR nor in the statement of the victim girl recorded under section 164, 161 or 164 of the CRPC, nor in the deposition. Yet she is languishing in jail for a period since
For 3 years, 10 months.
for a period of 3 years, 10 months. For a period of 3 years, 10 months. It is submitted that if the offense against the person has not been disclosed by the person in the examination. Which case where the person should be on the council for the state by the moving declare for the subject that the name of the prisoner was not disclosed in the FIR nor in a statement record statement of the victim lady, but what was subsequently disclosed by the
Co-accused statement. Co-accused statement.
by the co no doubt, that it is no longer a second that the statement of the court is not a reliable piece of evidence. And for the purpose of there is no difficulty on the part of the court to release that person. Furthermore, the victim lady neither disclose the name of the prisoner in the FIR nor in a statement recorded by the police or the magistrate. Even in the evidence, she did not disclose the name of the prisoner. Therefore, the role of the prisoner in any commission of an offense appears to be doubtful at this stage. Furthermore, the trial has commenced and the and the state and the deposition of the victim girl is at the stage of cross-examination.
No.
Complete.
Complaint the PW2 will cross-examine.
Okay. With the PW2?
Complaint.
No, is complete after the cross-examination. And the second witness, being a complainant, is still in progress. Be that as it may, in view of be that as it may, the totality of the facts and the circumstances disclosed at this stage does not instill any confidence, does not instill a confidence in our strength. If it is it does not instill confidence in involvement of the witness in involvement of the complicity of the witness in commission of the alleged offense. Accordingly, the witness shall be released on bail 10,000 rupees.
Lordship.
One must be local and attend each case. Subject to the condition on each day, he will attend the one default.
Lordship, one indulgence, Lordship, this petitioner belongs to Assam, Lordship. Another petitioner, another accused who has granted bail, who has abscond, now warrant is pending.
It is further informed to us that the petitioner belongs to the state of Assam, and there is every possibility that she would receive the liberty of bail. Taking into account the above, the petitioner shall not leave the jurisdiction of shall not leave the jurisdiction of the territorial jurisdiction of the police station where the case has been registered. And in the event she want to leave, must seek a permission of the concerned court. To the satisfaction of the yes. Yes, which one is the next matter? 1 minute is left.
One possible matter is there 18. Regarding
that?
information, my lord, 18.
What is the information?
It's fixed on 16th of August for the evidence of doctor and the IO.
16th August?
August. Date is fixed in the law.
How many witnesses?
2 witnesses left.
Left. So let us come back.
My lord.
We'll direct immediately on that day. They have to complete. And then Yes.
It is. And out of 13, only who has been examined for lordship.
Yes. This is in fact renewal of prayer for bail on the ground that the petitioner is in custody since 18 July 2022. And there is no progress in the trial. It is further stated that the petitioner was released on bail, but later on rearrested, having misused such liberty. The learned advocate for the petitioner submits that the other co-accused are already on bail. And because of the slow pace of the trial, which does not appear to be completed in near future, the petitioner should be released. We noticed from the record that the earlier application for bail filed by the petitioner being CRM 23 of 2023 was rejected by the earlier division bench on 27/2/2023. The contention of the petitioner that is languishing in jail for a pretty long time was available at the time when an earlier application was rejected. And despite this, the opposite facts being evident, the prayer for bail was rejected. We find from the said order that the earlier division bench rejected the bail application filed by the petitioner as he misused his liberty. There is no material forthcoming before us in relation to the conduct of the other co-accused, that they also misuse the bail, the liberty granted, that they also misuse the liberty granted to them. Which makes the petitioner stand on the same footing that of them. A plea sought to be taken that due to pandemic, these conditions could not be strictly observed, which does not appear to be work, does not appear to be of worth consideration. More particularly when the other co-accused who were also put to the similar conditions observed the same rigorous, and there is no allegation against them at the behest of the prosecution that they have misused such liberty. We thus do not find any changed circumstances except the period of detention. And therefore, we do not think that it is a fit case where the petitioner should be allowed. Furthermore, we find that the session trial has been activated, and in fact, the dates were fixed on 28th July and 31st July, where two witnesses were examined. The next dates are fixed on 30th September, 3rd October, 4th October, and 5th October for recording the evidence of the other witnesses. And therefore, it cannot be said that the trial could not reach to its logical end in near future. However, we trust and hope that the prosecution would bring all the witnesses on the aforesaid dates and shall not seek for adjournment unless necessitated by unavoidable and unforeseen circumstances, so that the evidence is complete in all respects, and the matter can be decided on merit. With such observations, the bail application is rejected, no order is proposed. Everyone. Yes, call. Your instruction.
The date is fixed on 16th of August for witness of doctor and the IO.
Only two witnesses are left. This much.
If these dates will not fail, next date is
How can you imagine that it will fail?
as because these two witnesses are left since from February
We are
2020.
saying that this prosecution will produce these two witnesses on those days.
There may be a mandatory.
We are mandating it.
All directions are mandatory.
The earlier application for bail, the CRM 624 of 2022 was rejected. So earlier application, filed by the rejected. CRM 7, filed by the minister, was rejected on 26/2022. Categorical observation that the prosecution will take all steps to complete the trial without seeking any adjournment. The second application for bail, being CRM 249 of 2022, was also Dictated on 5/2022. On a, on, returning a finding that the dates for recording the evidence of the witnesses have been fixed on 9th as 12th January 2022. And the further date for argument further date for delivery of the judgment was also fixed by the special judge. However, it is submitted by the petitioner that despite such direction, till date the evidence on the part of the prosecution has not been completed. And because of such delayed trial, the petitioner is still languishing in jail. The learned advocate for the state informed the court that the next state that all other witnesses have been examined except doctor and and investigating officer. The next dates are fixed on 16th of August. Only one day. The next date is fixed. Next date is fixed on is 16th August 2023 for recording the evidence of the opposite witnesses. Since the next date is fixed in the close proximity of time when the instant application for bail is taken up, and in view of the gravity of the offense allegedly committed by the petitioner, we do not think that it is a fit case where the petitioner should be granted bail at this stage. We have direct the prosecution to bring the opposite witnesses on the date so fixed and shall not seek for any adjournment. And full stop. Correspondingly, the learned session judge, the learned judge special court under POXO Act shall complete the evidence of the opposite two witnesses on the same day, and thereafter shall fix a next date for further action which should not exceed beyond 15 days from the date thereof, and ensure that the case has brought to an end within 4 months therefrom.
My lord, one intelligence, my lord, copy may be through the planet registered to the court.
Liberty is granted to the respective parties to communicate this order to the learned judge, special court under POXO Act immediately. Application first time. Thanks. Okay. Yesterday also he did not come.
I have an instruction to not place this application. 29 also. 29 also.
28
and 29.
Yep, 29 first time or
So I'm for the petitioner, I'm in custody since 6th January 2020. 3 years, 6 months, 10 days,
January
2020. 3 years, 6 months, 10 days left, I'm in incarceration. So for the list is concerned, the official witnesses are 6, out of which 4 have been examined, and so for the private witnesses are concerned, there has not been examined. And there is no contribution from my end for that inordinate deed.
When did the last examination took place? Last evidence,
Last evidence took place. Now, also one thing another. Kindly see the page number 70. There is a specific direction on the part of the Honorable Coordinate Bench,
2nd January.
2nd January, in the July 2017. In the second page, there is the page number 80. 6 months from the 17th January 2023. So that for this order is concerned, the case should be completed on the month of July, but the next date is fixed for 14th September.
Whether within that 6 months, several dates were fixed,
Several dates.
examination was done.
One.
Witnesses.
Only one.
Why? Yes.
I have already submitted judgment passed by the Honorable Apex Court on last day. On last day, I have.
Yes. What you have done?
Maybe please allow me to come back tomorrow. I will come with the latest status.
I am in custody more than 3.5 years. I've already submitted before your lordship one judgment passed by the Honorable Apex Court on the 3.5 years. Those persons got the privilege of bail. So I'm only submitting to your lordship. Already I have suffered. There is no contribution from my end. In spite of having the direction passed by the Honorable Coordinate Bench.
What is this going on when the court has directed? Why the learned judge has not completed?
Witnesses did not turn up, even on the last day. No witness turned up. I am very fairly submitting for.
Yes.
But you have to find out from the trial.
We are issuing a notice about the learned judge. We are issuing a notice on him when there was a direction of our him to complete it.
That's
why
why
he has not
later
done.
notice plan. Let him file a report.
And we are also directing the investigating officer to remain personally present before us.
He will, if my lord desires, but he has got no role to play.
Why not?
My lord, if the
He
court
has
is
adopted a dilatory tactics, not bringing the witnesses. What the judge will do?
Anyway, come with the latest position tomorrow, both of you.
So I will take up.
Yes, both of you come ready
No, my
tomorrow.
lord, if the trial court judge is directed to file the report, that may not be possible.
No. We are thinking not only in the form of the report, we just wanted him to appear.
As in,
But your investigating officer's role is also very important.
Lordship will bring it.
Which core, which?
Done it, additional cases that in detail is applied.
Anyway, bring the order sheets
Lots.
so that we can know we can get the picture.
Actual lordship, in that order, sheet, I can collect by the course of the day. I can get the status report.
Yes,
Please, Lordship, the IO is located at Calcutta.
Now it is the 1 hour.
Lordship, maybe a day's.
1 hour connectivity. No difficult.
That's it, on 12th.
Give a status report tomorrow. What has happened?
That-
as well as the defendant. Lordship, I am in, this is the renewal of prayer for bail. I mean, if you have it completely, yes, sir. I am in custody since 19th, 29th November 2021. In this case also, without any contribution from my end, the case is in a stagnant condition. Only on the grounds of.
21 witnesses are there. 21 witnesses.
21 witnesses.
How many are examined? 2 are examined.
So for mine. Oh, no, sorry, Lordship, not a single witness.
Not a single witness is examined. You are in custody from?
29th November 2021. Charge sheet filed on your Lordship. Charge sheet filed.
What are you doing?
5th August fixed for CSW 1.
Who is the first witness?
I think.
Victim.
Should be recorded.
Father of the victim.
First witness should be the victim. Bring that victim and get her examined. On
CSW
fifth,
1 is there.
on 5th, you get it examined. Come and tell us on 7th what has happened.
Specific order, my lord. If a specific order is given, my lord. As
On
per
the board.
CSW 1, my lord, the father of the victim, my lord.
There is already a direction that on the prosecution, that in all the POXO cases, the first victim should be, the first witness should be the victim.
Now she is. So in this case, I am sitting one day, and I cannot do that.
Yes.
Lordship. Lordship, allegation under section 498A 304B 34 of Indian Penal Code. Lordship, charge sheet has already been submitted under section 498A 304B 34 Indian Penal Code. Lordship, there was a love relation between this victim and the petitioner. Lordship, thereafter they married in a Kali Mandir. After that, due to the torture from the family of the victim girl, she committed suicide, Lordship. Because the petitioner earned less, Lordship. That's why, and she has married upon her own choice.
So,
Can that be a ground for minor suicide? For dowry death? That he earns less, that is the reason why she committed
within
suicide.
15 days of her marriage,
And dowry demand, minor, she committed suicide. Treatment of the minor.
Lordship, she herself escaped from her house with
Any-
this petitioner, Lordship.
any,
Time declaration, no, no time. What?
Married within, my lord, she died within a period of 1 month.
15 days
Yes,
of the
ma'am.
marriage.
Lordship, this is a Lordship. There was a love relationship. These are admitted facts in the FIR, Lordship.
What does it connote, madam?
Lordship, she herself lived away with the petitioner and married with this present petitioner. Lordship, she used to call the family member her paternal house. They were against this marriage, Lordship, and she was in a situation, Lordship, a
What is
girl.
the Place of incident where? Place of
Lordship,
incident.
her parents did not allow her to enter into her house.
If she chose to flee away or fled away with the petitioner, then she was confident that her family member will not accept this relation. Can this be a cause for a suicide? She's conscious
Lordship,
that
she
then if the family members are agreeable, there was no question of fleeing. There was no question of fleeing. They were opposed to it. That's why the question of fleeing. If she has decided to go with you, then what was the occasion within 15 days because the family members were not accepting suicide? Is it believable story, madam?
Lordship, she cannot take that one, that her parents
What,
are
she
not
fled,
accepting.
then why she fled away? He was conscious that my family members will not accept it.
My lord, two
Lordship.
points to be considered in this case, my lord. The mother-in-law and father-in-law as absconded.
Absconded.
Authorship. My lord, on 14/6/2023 only he was arrested, my lord. 14/6/2023.
No, no, 11/4.
And date of incident when? Oh, 11/4/2023.
My apologies, my lord. He was arrested on 11th of April
I
2023.
have seen that from the petition, sir. Before you read, I have read it.
And he's in custody from?
11/4/2023. 11/4/2023.
Lordship, charge sheet submitted. Lordship, investigation over.
Where
Lordship.
is your
presumption
father and
one-
mother? Where is your father and mother? Yes, tell us,
Lordship,
where is your father and mother?
Lordship, they are staying at home, Lordship.
They are staying at home. We are directing the police to go to your home immediately, today itself.
Lordship,
Don't you
kindly,
do-
Lordship. Lordship, whenever this victim girl used to call her parents, Lordship, they used to abuse her with filthy languages, Lordship. Out of depression, she has
Madam,
committed
is
suicide,
it a
Lordship.
believable story that a girl was in desperate love with the petitioner? She
Lordship.
knew that her family members are not agreeing to this relationship. She fled away with the petitioner. And then because the family members means the parents were not agreeing, she will commit a suicide. Believable story from a
Lordship,
normal
she was,
circumstances.
sir, Lordship, she was
What
in
are you
such
talking?
a situation.
How many witnesses are there to be examined?
My lord, there are total 25 witnesses.
No, in a case like this, 25 witnesses.
25 witnesses. Name and addresses of the witnesses. 25.
What are you talking?
Well, I have not seen the
25 witnesses
I
in a
find
case like
three,
this.
I find three, 161 statement.
Just imagine, 25 witnesses.
particular witnesses to be examined. 25. That's that.
What 25 people will do?
But my lord, SIs are there, my lord. Three relatives and two neighbors are there, my lord.
The petitioner is in custody since 11/4/2022 in connection with the application. And filed an application for the on the ground that the charge sheet has been submitted. And therefore there is no occasion for a custodial trial. It is submitted by the learned advocate for the petitioner that there was a love affair between the petitioner and the deceased girl. But because of the mental torture perpetrated by the family members of the deceased, she committed suicide. It appears from the state opposes the prayer for bail and submit that the case has been registered against 3 persons, namely petitioner, the father-in-law and mother-in-law. But the in-laws are still absconding and preventing the arrest in connection with the incident. We find that there is a serious allegations over the complicity of the petitioner and the other co-accused in commission of the offense. Furthermore, the deceased committed suicide within 15 days from the date of the alleged marriage. The story set up by the petitioners at this stage appears to be doubtful and needs a stronger evidence in this regard. Considering the gravity of the offense and the alleged role of the minister and his complicity thereto, and the fact that the other two accused are avoiding the arrest. We do not think that it is a case where the petitioner should be allowed to bail at this stage.
Grateful, Lordship.
Lordship, for the purpose of re-appreciation and maybe permit to say, on last date, I have produced a judgment passed by the Honorable Coordinate Bench that the column 10 of memo of arrest was vacant. But in my case, the column 10 was signed by a member of the rating part. In this context, Your Lordship, I want to relate to judgment of Your Lordship where the rating party put the respective indicate the memo of arrest and the context of this to observe.
What about the Supreme Court judgment on that? I could not lay a hand. Yesterday, I did not find time, frankly.
Your Lordship, so far my
Then
I
have you
have
got the
tried to
judgment?
search out.
No, I have searched the
Give me
judgment.
a day's time. Come tomorrow, I will find it.
I didn't find the judgment.
Come on.
So, Honorable Coordinate can be done, but
Let us see, let us see.
why not, may I produce the TK versus judgment?
Yes.
I'm for the petition, Lordship. Lordship, this is a case under section 6 of the POCSO. The victim girl is aged about 17 years, 6 months at the time of lodging of the FIR. The FIR, if Your Lordship only goes through page 10 of my petition, has been filed by the father of the petitioner, Shapun Das. Lordship, I humbly submit that the FIR is very, very against the petitioner. But I have a point to make to apprise Honorable Court that there is the chance of false implication of the petitioner cannot be ruled out from the documents of the court of the government document. Lordship, as per the FIR, it says that the petition on the date of FIR, the victim lady was seen to vomit. It was inquired and found she was 3 months pregnant. And Lordship, it was also found on inquiry that for the last 3 years, she was having sexual relationship with the petitioner. Now here I pause, Lordship. The fact lodged by the father of the petitioner do not support the case of the prosecution from the 164 statement made by the victim before the magistrate. The alleged act of this petitioner, if as per the 164 statement, it is in para, Lordship, para 17, starts from para 16, the relevant portion is para 18, Lordship. If we take it to be gospel truth also.
Yes, which page?
Para 18 is the relevant part.
Para 18.
Page 18, paragraph 12, Lordship. I beg to apply.
Page 18.
Page 18. And 19 is the most vital part. Now, Lordship, the alleged act played by the petitioner as per the 164 statement before the magistrate does not justify that by this act, I ask a question to myself, the petitioner can be pregnant. There is every possibility that she might be impregnated by any other person. And
what is the any medical examination report? Oh, medical examination report supports pregnancy.
Supports pregnancy, but
When you
my act does not support, Lordship.
medical examination, that's
Lordship. She may be impregnated by some other person, and out of fear, my name has been,
Page number
because
37.
the
37.
the touching, it does not come to 4 or
Please
6.
correct
Lordship.
at page 18, what she said.
Lordship.
164 Lordship said, Lordship, thereafter, Lordship, for DNA profiling, Lordship, sample was collected, exhibit or as sent to the FSL, Lordship.
What is the outcome of?
No, Lordship, on May 30, Lordship, 23, send the sample, Lordship, exhibit, a report not collected.
My lord, I beg to say, if my role was to that extent, what she has stated, I am not going to repeat it. I cannot, she cannot be impregnated by me. It's a 164 statement before the magistrate, and she is not a kid, lordship. 17 years, 6 months at the time of lodging of affair. Now she is about 18. It's a borderline case. She knows what she is doing. I'm in custody since 8/4/2023. Charge sheet has been submitted. And my role is no 4, no 6, lordship. It's maximum 12.
Lordship, report is pending, Lordship. DNA test.
How long will he days detention without any established rule of law is an infringement of a fundamental right?
Lordship.
You have to go by the statement of a girl. Yes. And the magistrate has recorded that she understands everything. She is capable of understanding everything. She has said so. And, this is a very big question on the.
Section 4 and 6 is not applicable.
There is something which he has.
12, 3 years punishment, lordship. 3 years punishment maximum. Four and 6 will not be there. Oh, petty assault. And 60 is a senior citizen, lordship, 65 years old.
That's more damage.
Lordship, he was the chance of false implication cannot be ruled out, lordship. Seeing anything. Out of fear, lordship, because lordship understands I cannot, she cannot be pregnant due to me.
Yes. You got a judgment.
Regarding this worship,
The vacant is one thing. And the name of any of the public officer. is
Lordship,
different.
This is the vacant, earlier coordinate.
it's
bench.
not that. Lordship, I have,
There are judgments of.
I have searched for the judgments. But not in my favor. I did not get it in my
No,
favor.
no, that is the one issue. There is two issues are there. One is column 10 is blank.
Blank.
That stands on one. Second is the column 10, there is a name. But is the public officer or the part of the rating? Whether that is a sufficient compliance there or not. These are the two.
Another issue I also find. It is fined by the
But
police
here
officer.
he says that it is a case where it is blank.
Blank.
When it is a blank, then the earlier judgment has to.
Lordship, from Taylor versus Taylor to our recent Lordship knows better than me.
Whether fined by the
Yes,
police
ma'am.
officer, then vacant, my lord. This is another. First by this coordinate, earlier coordinate. This is the charge.
The analogy.
That is not binding on me.
No, my lord.
No, no.
But for your.
We can take a different view.
Yes, my lord. Yes,
Yes, and we are referring the matter to a larger.
I am sure, sir.
And you remain in.
No, this is with regard to the judgment which was blank.
I referred this blank.
This is relied upon here on the last occasion.
Yes, last occasion. Another passed by this same coordinate when signed by the police constable. I referring this.
In case of if it is signed by the police person.
I know, I have.
Police personnel here, Lordship. So there is a bar and did not get any benefit of column in DK versus judgment. What
No, DK Basu judgment is here.
Here, the column number 10 is totally blank, your Lordship. But some cases, your Lordship.
But there is a name.
Yes, your Lordship.
So I wanted that where there is a name.
Coordinate bench judgment.
Coordinate bench.
So what is the name?
Name, your Lordship.
Who was the
Jafar
witness?
Ali.
No,
Petitioner.
Yes?
no.
Jafar Ali.
This is a coordinate by judgment.
Coordinate.
It is.
What is the other? You show us.
Yes, your Lordship.
It
Give
is
it
my
to us.
judgment.
Give it to us.
Question here, the rating team. I'm not last
Just one. Yes.
Lordship, this is the said judgment which I was referring that on the, this was argued by me only.
In these two cases, the earlier judgment was not referred. The earlier two cases, Shahinur Bibi and this Chandra Bahadur Tamang.
No.
These earlier two cases were not referred by you.
The Jaffran is concerned on the last participant that was observed, this part is freedom.
Where? No, in this.
Because DKWC was not considered, and that judgment was relied upon the other side. But part is freedom, the last honorable court. I will give you one more card. Come on, I will. I have the. And that was part in freedom, observed by the last honorable court. I will.
Correct. Prove my notion which I have gathered in this regard to be wrong.
We have
Yeah.
to assist your lord, but I will submit the rest of the.
Yeah. Because my opinion is prima facie, tentative is just reverse.
Now, that was.
The judgment in Sainur appears and the other appears to be per incurium because of this judgment of Jaffar.
But Jaffar was part in freedom for the last quarter.
Let us see.
I will find.
Lordship, then hearing me of this.
No, but I tell you very frank, this is there. If I find there is a conflicting decisions, then we'll refer the matter to a larger.
Lordship, in that
We will
case.
not keep it. We will not keep it.
In that
with
case,
us.
Lordship, I would like to.
Because per incurium theory creates a lot of problems.
Conflicts.
Let
Conflicts.
us see. Come tomorrow and give it. The judgment, what the party does.
Our cases is 10,000. Another one in the. My cases are also pending. Analogous.
Let us decide one. was not obtained. And for such reason, the prayer for extension of time to complete the investigation was made. It was eventually granted on 17/1/2022 for a period of 60 days. Subsequently, after obtaining the official report, which indicates that that it contains a the contraband substance. Some other charge sheet has been filed. Filed on
12 March 2020.
2022.
After left of
And
one.
there is now what is the state?
No,
Blood. Doing. Lordship. It's really alarming. It's really alarming that since after the filing of the charge sheet, the copy and all the relevant documents which are required to be given to the minister has not been given as yet. It's the court which gives or you give.
No, court will give me lord. Under 207 CRPC.
We are unable to comprehend that there is no attempt on the part of the judge to ensure that the relevant copies of the relevant copies of the materials, as well as the copy of the charge sheet, has not been served upon the petitioner as on date. More than a year has elapsed in this regard. So we therefore direct the London judge to ensure that all the relevant materials, documents, as well as the charge sheet is given to the petitioner within a period of fortnight from the of the communication of this order. The trial court shall thereafter make endeavors to commence the trial within reasonable time, and shall ensure that it has brought to its logical end within 8 months therefrom.
Let this order be communicated by the registry, my lord, to the London Trial Court.
Liberty is granted to both the parties to communicate this order to the concerned judge.
Great.
Yes. What? Let us see. We are aware, we'll sit on one day. You are not aware that on an administrative side, what has happened? You did not have to mention, we know what is there. We will take care of that. Don't worry, we know what to do. And be prepared to face. Be prepared to face. So. No.
কোড দেখা যাচ্ছে না।